that way. But moving on, and we will try and breathe, but also present fast because we still have a lot of room to cover, is communication. And I think this is something that you've heard us say a lot. So like I said, I'll cover it pretty quick, but and it goes in line very quick or very easily with training, which is this idea that communication is open. Staff members feel comfortable speaking up. They understand who they need to report to. You're relaying that this is important to the organization. Because remember, and Brooke said this really early on, but I'm going to say it again because I think it's very important. 90% of whistleblowers report internally first. Nothing was done. Nobody responded to them. Nobody took it seriously. And so when you have that open feedback, when you have those types of communication, when you solicit feedback, when you also close the loop with the employees and tell them, well, we can't tell you the outcome of the investigation. We have investigated it. We have taken action. That type of communication is valuable. But soliciting the feedback, maintaining visibility with employees. And again, as a manager, you may not be the compliance program person, but being open to receiving complaints for your employees is very, very important. Making sure that you have several different avenues to report is very important within the communication and reporting lines. Making sure that there are hotlines so people can report anonymously, email and hot boxes, and then again, I think this has just become maybe a broken record or reoccurring theme. But maintaining that visibility, having compliance corners in newsletters, or like for us attorneys, every month or so you can sign up to get an email from the disciplinary council about your ethics tidbit for the month. And it's usually just a quick little thing, but it's an important reminder of our ethical obligations. Your compliance officer or your governing body can do a similar ethic or compliance email of the month with a short little story, but having those open lines of communications between your compliance officer and your employees, your independent contractors, making sure that everybody understands this is an open structure. There's no retaliation for coming forward. You can be anonymous if you want to be, because that's often an important concern of people. We just want to be anonymous. We see something going wrong, but we don't want someone to treat us differently because we came forward. And then two, with that open lines of communication, your compliance officer having regular reports with your board, which goes back to some of that compliance reporting structure that Brooke was talking about earlier.
All right, well, I'm going to talk about element number 5, risk assessment and internal auditing. So first item would be risk assessment. So, what is a risk assessment? Well, it's really a culmination of a bunch of things. You have to understand your organization's risk. So what is your organization's risk tolerance? Identify priorities. And you also need to kind of assess your organization for potential weak links. The best recommendation we can give you on risk assessment is, don't just start randomly auditing. Like, don't skip the risk assessment step. That's important. And you can prioritize your risk by looking at past risk assessments, past compliance issues in your organization, recent enforcement from the DOJ or the OIG or CMS, or all the different Medicare contractors that are out there auditing. And so you can use those things to identify the priority to create your risk assessment. And then it's key to periodically update your risk assessment. I think Amanda said something a little while ago about having a risk assessment that you did, 10 years ago. Best practice would be to do some sort of risk assessment annually. Maybe it's not like a full-blown assessment, but it's just kind of taking a look at, have there been changes in state and federal laws or regulations? Have we had a big compliance issue so that we need to focus in on that risk area? And again, focusing on policy development where appropriate. So next slide, please. So what is an internal audit? And this is, I think, a pretty good definition of what it is, in the sense that you're trying to take an objective look at what's going on within your organization to evaluate and improve the effectiveness and for risk management, for control and governance processes. Now, I like this slide to kind of highlight where we see the role of auditing, and you'll see it's kind of far down on the slide. So from a compliance standpoint, your first line of defense is really your workforce carrying out their day-to-day activities. They've been trained on the mission and values. They've been trained to do the right things, for the right reasons, and you're just expecting for them to carry out those responsibilities. That's your first line of defense. The second line of defense is really the quality, the compliance and quality assurances that you have in place, in the sense that you're focusing on regulatory requirements, you've got the appropriate policies and procedures in place. And then your third line of defense is really the internal audit piece, where you select a certain service line or certain activity, and you do an audit to see, okay, are the first and second lines of defense working, or do we need to make some changes? Next slide. So some key points when you're thinking about auditing. So, the difference between auditing versus monitoring. Monitoring is more of a day-to-day type of quality assurance process. It's routine spot checks, whereas auditing is a more formal process where you've thought out, you've done your risk assessment, you've done your planning, you've done your prioritizing, and you're really looking to quantify potential errors or noncompliance or potential financial losses to the organization. There can be several kinds of audits, but the baseline audit is kind of the snapshot. So if you haven't done an audit of your radiation oncology department before, the first audit you do is going to be the baseline, and you'll compare future audits against that baseline. And it also will help you prioritize issues needed for training or policy development, and can serve, like I said, as a reference point for future audits. Routine audits are, as you'd expect, they're on a defined schedule. So maybe it's quarterly, maybe it's twice a year, maybe it's annual. And you're typically in a routine audit, you're not auditing everything. You're looking at a smaller sample to see if you have an issue or if you're pretty compliant within that in that service line. And then investigations from time to time can also lead to audits, so that if you get a tip on the hotline, or you get some sort of letter from a government contractor, that could trigger doing an audit to try to validate the concern, identify the cause of the noncompliance, quantify, and again, try to figure out the organization's exposure. Next slide. Areas of focus. This gives you a whole list of this potential areas that you can focus on. Government audits. So if the OIG is auditing something, you should be auditing that same issue within your organization. Corporate integrity agreements, those are the settlements that the government enters into. They can be a good source of areas that have been targeted by the government and should be on your radar to make sure you're in compliance. Billing and coding, documentation, those are always, you really can't focus on them enough. I mean, they're constantly popping up in the government investigations. And then naturally, if you've had a prior area of noncompliance, you're going to want to continue to audit that to make sure that the corrective action has been implemented, has been effective, and people haven't gone back to their pre-corrective action ways. Next slide. Effective audit plans. We've emphasized the education and training, and actually auditing can be another effective way to use that education. It's an opportunity to educate on what the mistakes were. Sometimes people haven't been properly trained on the use of modifier 25, and an audit can demonstrate, oh gosh, we didn't appropriately educate them. Let's explain to them what they did wrong here. It can help promote change within the organization. So that we've identified an issue, we're going to fix it, and we're going to correct it going forward. It helps you react to the noncompliance and do appropriate reporting if needed. All right, Amanda, next slide, please. Don't forget, this is one of those takeaway slides, and that's why it's in bold and underlined. If you really think you might have an issue from a civil or criminal standpoint, or this could be, we've had a billing issue potentially going on for 6 years, and we're going to have high overpayment liability, make sure that you consult with your legal counsel. Legal counsel, between the client and legal counsel, the attorney-client privilege, and to the extent there needs to be the retaining of an outside expert, somebody maybe to review claims, review documentation. it's important in this type of situation where there's high potential exposure that your lawyer engages those to try to protect the attorney-client privilege with respect to the review you might get from that independent, that third party. Sampling. You typically, when you do an audit, you don't just audit everything. You're going to start with a probe, a smaller sample, and usually that's 30 to 50 claims, units, whatever you want to call it, just to get an idea. Okay, do we have an issue, or are we compliant? So that's usually the first step. And then depending upon, and you can go to the next slide, Amanda, depending upon what your error rate on that probe sample is, if it's more than 5%. You might want to take a closer look, which leads to doing a statistical audit, where, again, we're not auditing every claim, but we've taken the universe of the claims and we're selecting a sample size that will give us the confidence and precision levels as required by CMS and OIG, so that we get an error rate and that you would extrapolate that across the population of claims. Process. This is important. You can't audit every department. You can't audit every provider, unit, service at all times. And so coming up with an inventory, a regular auditing process, so that you're constantly auditing departments, but you're not auditing the same department over and over and over again. And I think it's also important. You have a plan, just like you have a plan with doing the risk assessment. You have a plan with doing the auditing, so that you have the appropriate people involved. You've defined what the issue is. You've defined the scope. So it's going to be our radiology department. It's going to be for the last 2 years. Objectives. You've identified what you're looking for. You've identified the resources, and you've named what your sample, what the sample selection is. So is this a probe? Is this statistical? And after you complete the audit, you're going to have findings, and so you're going to need to figure out, do we have an issue? Did we identify non-compliance? And if you've identified non-compliance, there's usually a root cause analysis component to it to try to figure out, well, what caused this? Was this a lack of training? Was this a lack of policy? Was this intentional misconduct? I mean, from time to time, you do have intentional misconduct. And then getting the appropriate corrective action plan in place. And tracking that to make sure everybody complies with that corrective action plan. This next slide, with respect to auditing, sometimes this may trigger a repayment, or it's an overpayment situation. So you need to make that appropriate repayment. There may be a disciplinary action. We may need to take some sanctions or do additional training with an employee. And then with the corrective action plan, there's ongoing monitoring to make sure that compliance is maintained and we don't have further issues in that particular issue, with that issue that was identified. OIG audit tips. These have come from the Office of Inspector General. And the OIG encourages providers, you don't just focus on the money, also evaluate what caused the problem, which makes sense. It's not just about paying the money back. We want to fix it so we don't have to pay back money again. Review the OIG self-disclosure protocols and their corporate integrity agreements. And we have some links at the end of the presentation to some of those resources. You can see what the OIG is looking at, how they create their samples, and try to mirror that when you're doing your sampling. OIG encourages proactive reviews of coding, of contracts, and quality of care. So again, this whole be proactive, not reactive. And then the use of audit plans and corrective action plans, like we just talked through on the previous slides. Remember, ignorance is not bliss, going back to Amanda's ostrich, burying your head in the sand. It doesn't work for the government. It doesn't work for your organization. You are obligated to be proactive. And I kind of midway down that slide, I referenced the 60-day overpayment rule. It requires proactive compliance activities. And it also, if you learn of something, you've got to complete that good faith investigation. And if you have evidence of credible, information of a potential overpayment, you got to do that investigation. You got to pay it back if it comes to be an overpayment. All right, next slide. All right, Amanda, I'll let you take over on enforcement.
Yeah, the big scary reason I think a lot of people are concerned about compliance is enforcement, and it does not need to be scary. Again, part of enforcement is just taking and all of your wrongdoing. I mean, taking any report seriously and appropriately reacting to them, making sure that you're enforcing your policies consistently, and that is usually done through appropriate disciplinary action. And we list on this slide a couple of different factors that you're going to want to think about when you're looking at the appropriate disciplinary action to take. Is this a repeat offender? Was it willful? Who reported it? When was it reported? What type of disciplinary action have you imposed for similar violations? Did the employee that violated the code of conduct cooperate with the investigation? What were the nature and the ramifications of the particular violation? These are all different things you want to think about when you're responding to and enforcing a particular policy and a violation of that policy. And the reason you want to think about all those different things is because there's a range of disciplinary action that is considered to be appropriate. If it's something that is brand new, that there really hasn't been a lot of education on it, education may be appropriate. If it's something that maybe that they were only trained on when they first came on the site of 20 years ago, again, education may be appropriate. And this is an escalating scale, as you can see as you follow down, that there are different options or ranges that you can have of disciplinary action that should be based on those other factors. And as you're looking at those factors and as you're choosing the range of disciplinary action, document that disciplinary action, document the different things that you considered in imposing that particular disciplinary action. And this is why you often see HR involved a lot, because a lot of this disciplinary action has to do with HR issues, particularly if you're terminating somebody or demoting somebody. But it's a good thing to have, documentation of what that disciplinary action was in their record. So if something comes up again, you can see whether what has worked, what hasn't worked, and have that record of it. And then your response. This has to do with your investigation. So somebody comes forward, they report it. You want to make sure that you're walking through everything that we've talked about so far in this presentation. You're conducting an investigation, and the appropriate person is conducting the investigation. That may be the compliance officer. It may be appropriate to take it to legal counsel, and part of the reason for taking it to legal counsel may be to invoke that attorney-client privilege. If you need to get an outside auditor involved, depending on the report. So the investigation is going to vary, but make sure that that person that is investigating understands the policy and procedure, understands what is expected, and also understands how to conduct interviews. And I'll get into some tidbits on interviews here in a minute. Making sure that your organization is appropriately responding based on that investigation. Do you need to notify the government? Does a repayment need to occur? Do you need to self-disclose something? Are you taking the appropriate disciplinary action? Are you implementing an internal corrective action plan? All those different pieces are part of your investigation, part of your response. And again, document. Make sure that you have documented the investigation, documenting your response, looking for trends, looking for how this is working in your particular organization. Some interview tips. Interviewing is an art, I think. And so here are some interview tips that can be helpful. 1, 2, that is not on this slide. Interview separately. Do not group interview people. People tend to remember things in a group, or they'll remember something somebody said, which is not what they saw. So interview separately is another big one. But silence can be a very powerful tool. People cannot stand silence. They will want to fill the void with talk. They will always think that the silence is longer than it really truly is. And you'll get more information that way. Ask a question, let them respond. Before you ask the next question, maybe let there be some silence in there, because they'll give you plenty of information. Consider it to be a circle of that interview process, with the perpetrator being in the middle and working into the outside. Ask the broad questions. Don't ask leading questions. Let them explain their narrative. Let them explain it to you, how they actually recall that particular, how they recall that event. Ask questions in chronological order. Don't jump around. It confuses them. It's going to confuse you. You're going to get information incorrectly, or that isn't an accurate reflection. Asking one question at a time. Get specific. Be straightforward. Ask open-ended questions. Avoid asking why until the very end. Get as much information as you can and before you start getting kind of to the heart of the matter, because you're going to find out information that you didn't know, and you're going to need to ask follow-up questions. The other big thing is also consider the demeanor of the interviewee. If they get combative or responsive or evasive, take note of that, because there may be more to follow up there. But just be alert for things that you haven't asked and don't feel like you have to stick to a script. Make sure you follow up on all the information that comes forward.
Just one thing I would add, Amanda, there, when I do interviews, one thing I also like is if you can have two people be in the room so that you can have a question asker and a note taker. I mean, when you are trying to ask questions, it is very hard to take detailed notes about what you're hearing. You're just trying to, process, think of the next question. Sometimes they say something that takes you down a rabbit hole, then you're trying to, get back to your notes. So if you can do it with two people, it gives you the ability to have one person ask the questions, one person take the notes. It's also nice too, then you have also kind of a witness. So it's not like a, employee he said, she said type situation.
Yeah. Then your communications with the government. Remember, you get credit for reporting. I mean, one of the things in the various sentencing guidelines, DOJ credit, is you can get some of that sentencing credit or that enforcement credit by reporting and by having documentation and by timely communicating with them. And so remember, you can get that type of credit. You can also get credit for your internal audits that Brooke was talking about earlier. If you've conducted an audit, appropriately responded to it, again, the government is not going to say you must be perfect. But if you've done those audits, if you stayed on top of it, you're going to get credit for some of that. Do not ignore subpoenas. Please don't ignore subpoenas. It makes my life more difficult when you do. But maintain copies when you do respond to one, particularly if you don't use legal counsel to respond to subpoenas. One of the first things we're going to do is ask, well, what did you turn over? And if you don't have a copy of what you turned over, it can be very difficult. The same with search warrants. Request a copy of it. Notify your compliance manager. Maybe if you have in-house legal counsel, notify them. Document everywhere that they went, document the things that they took, so that way you can respond and create an inventory. But you are always cooperative, you're always respectful of the people that are there, and that will go a long way. So some risk areas we wanted to identify for you today. This one comes straight out of the Missouri backyard. The Attorney General Schmidt reached a settlement with the St. Louis County Nursing Home for Medicaid fraud. We do see Medicaid fraud enforcement. This was a failure to provide necessary care to residents and submitting false claims to Missouri or to Mo Health Net. The issue had to deal with care of pressure ulcers and bed sores. Again, part of it was a documentation issue. The care provided was not adequately documented, and that resulted in a false claim, but ultimately they reached a settlement or restitution and penalties of about $150,000. But you don't have to be living in Florida or New York for the world for there to be enforcement actions. Another one that is maybe a little bit scarier for rural hospitals is the 10 defendants that were charged in a $1.5 million rural hospital pass-through billing scheme. This resulted in the indictment of both hospital managers, laboratory owners, billers, and recruiters. What happened in this particular situation is the defendants would come in and take over some small rural hospitals, usually ones that were in financial trouble. And I believe those hospitals ranged from Florida to Wisconsin and even one in Missouri. And they kind of took over with their management company. They set up a billing structure where they would bill private insurance companies for expensive lab tests that may not have been medically necessary, which is a problem. And those lab tests were also not conducted in the hospital that was billing for them. They were actually sent to an outside lab. Ultimately, from November 2015 through February of 2018, they billed approximately $1.4 billion in those laboratory tests, and those hospital managers, laboratory owners, and billers paid about $400 million in claims at this point. That was kind of a mess. There's been a recent enforcement action in Oklahoma City. This had to do a lot with fair market value. There was free or below fair market value for office space, employees and supplies offered between the hospital, the management company, and the various physician support groups. That is a violation. The compensation was in excess of fair market value, also a violation of various laws, both federal and Oklahoma laws. They were given preferential investment opportunities in connection with anesthesia services in this particular scheme. Ultimately, it was a $7.3 million settlement and a 5-year corporate integrity agreement to settle this particular False Claims Act allegation. So there's a lot of local recent. I think all these were within the 2020 timeframe of enforcement actions. So that leads into another big area, and a big area that I've actually been dealing with over the past couple of days is background checks on employees. We're seeing a lot of people that they selectively screen employees and vendors. They don't do them all. You need to do them all. You have a responsibility as a healthcare entity to conduct background checks, and that might range under state law. You may be responsible for doing a local highway patrol background check on your various employees, and that can go all the way from licensure to exclusion. So making sure you understand which background checks you're responsible for conducting, but then also conducting them, and not just conducting them at hire, but on a monthly basis. Licenses lapse, licenses don't get renewed, and making sure that you're conducting all that are expected to be conducted. The big part of the big reason for this is that there's the 2013 OIG Bulletin on Exclusions, which had very broad sweeping statements in it. No payment for goods or services provided by an excluded service person. And that doesn't even go into, it's no payment for direct care, indirect care, administration management, executives leadership roles. That excluded provider is not just someone that is providing services, it's your entire organization. People go, well, I don't know where to go to check for exclusion. Here are your links. It's not a difficult link to find. It's not a difficult link to search on. You're also going to want to screen against the SAM program. That's the government contracting program. Make sure nobody's on that list either. If you've discovered that you have an excluded individual, you might want to self-disclose. We recommend consulting legal. But also, please maintain documents of these searches. Screenshot it. Print to PDF. Do something so you have proof that when you ran that search on August 1st, they had a valid license. They were not on the OIG list. And that way, if their license lapsed on August 15th and nobody notified you, when you did search that month, it was valid. Checking for licensure. This is one of the issues that I think I've seen recently, and particularly, previously, or at least last year, we had a lot of COVID waivers on allowing people with licenses to practice across state lines that they may not normally have been permitted to practice across state lines, and now they're just still there. And so confirming that they have an appropriate license certification registration within that state, and then regularly updating that. We did see recently a Delaware hospital had self-disclosed to the OIG that the licensure of 2 nurses had lapsed. One of them had been lapsed for more than 18 months. While hospitals don't bill Medicare directly for nursing care, there is a condition of participation, and there's a condition of participation for nursing homes too, that nursing services have to be furnished by individuals with current and valid licenses. Actually, there's Missouri licensing laws making sure that you're checking the licensure of all the people that are licensed and working in your facility. This hospital settled they self-disclosed, and they settled for about $180,000 using a kind of an interesting part of the self-disclosure plan that dealt with the total cost of employment, and contracting was how they kind of reached that amount, because you don't bill separately for Medicare for nursing services. But it was certainly a reinforcement that you have to make sure your people are appropriately licensed.
Okay, outsourced providers. This is another risk area, and I'd say it's become more of a risk area in probably the last 5 years or so. And so, what do I mean by an outsourced provider? This is a situation where maybe you're a hospital and you outsource, you contract with another company to provide wound care or physical therapy or behavioral health or telehealth or equipment. And the question always comes up, next slide, Amanda. We're hiring these outside providers because of their expertise and the quality they bring to it and their experience, and they have more of that than what we do as a provider. Otherwise, we wouldn't be, contracting with them to provide the service. So then I have clients ask, well, our wound care department's getting audited by Medicare, Brooke. I mean, are we responsible for what this outside wound company did? And my answer is yes, which always seems to shock the client, because they're saying, hey, we contracted this out. But what the government says is, no, it doesn't matter. You're still you're still providing those services, even if you're doing it under contract. So you're responsible for making sure that outsourced provider is billing correctly, documenting correctly, medical necessity is there and documented, and that quality care is being provided. So if you have, next slide, if you have these types of arrangements, make sure that these questions are, on your mind when you're entering into those contracts, to make sure that they're allowing you to have access and you are auditing their documentation, that they are obligated to follow your policies and procedures related to documentation, billing, and quality care, that they're required to train their employees. Next slide. And, it's important, and I try to encourage clients, if they can, to negotiate indemnification provisions with these outside providers, so that if you are in an overpayment situation, that they're obligated to indemnify you at the very least for the fees that you paid them that you are now having to pay back to the federal government. Another risk area would be medical directorships, and this is in light of the fact in December 2020, the Stark Law what regulations were updated to include a new definition of commercial reasonableness, amongst other things, and why this is something that should be on your radar. It relates to really the comments that were made in the rulemaking, that it seems like everything's cyclical. We haven't heard a lot on medical directorships, and now with the update with the commercial reasonableness definition, now it's back on the government's radar. And they were very clear in the rulemaking that medical directorships must serve a legitimate business purpose. On its face, the arrangement may appear to further a legitimate business purpose, but if there's duplicates, if you have 2 medical directors for your emergency department when you only really need one, then that may not be commercially reasonable, and that could cause you issues from a compliance standpoint. So what we recommend doing is a medical director needs assessment, which is something that you do across the organization, so that you would identify all your medical directors and all the medical director agreements and the areas in the hospital where they're providing those medical director services. You would develop an inventory so that you understand the type of specialty, the number of hours they're working, the size of the department, and who is that medical director reporting to, who has oversight over that medical director. You can contact interviews within the stakeholders within the organization to kind of understand how medical directors contribute to the organization. Obtain an idea to justify why you might need more than one in the same specialty or in the same department, and how need is actually for medical directors determined within the organization. And then, of course, you need to review the legal, regulatory, and accreditation requirements. Is a medical director required by law? Sometimes it is, and sometimes from an accreditation standpoint, your accreditation organizations require you to have medical directors. You can compare yourself to similarly situated healthcare institutions to see, do they have 2 medical directors in their ED? And then additional considerations can be, who's approving within the organization new medical directors. How is the need determined? How often and how are you tracking your medical directors? E&M is another new issue to be on everybody's radar. I won't go into the nitty gritty of how the Medicare physician fee schedule is computed, but essentially there's a budget neutrality factor with that goes into the reimbursement under the Medicare physician fee schedule. So if you give it to one area, you're taking it from somebody else, and E&M providers who have primarily in office practice benefited from the giving and taking this go around, which means for you from a physician contracting standpoint, next slide, Amanda, that there may be an impact on your physician contracting, so that you may need to renegotiate some of your provider contracts, so that especially if you had employed family practice doctors, they're basically working the same amount, but now getting more RVUs because of this give and take. And so you're essentially paying the physician more compensation for the same amount of work. And then for specialists, it's the opposite. They're getting paid less for the same amount of work. So if you might want to take a look at your physician contracts, from a reimbursement standpoint, to see with the change to the E&M rules, if that has fundamentally changed your compensation, to make sure that your compensation under your physician agreements is still fair market value and commercially reasonable. Next issue would be drug diversion. That should be on everybody's radar. It seems, the reports I've read during COVID, drug diversion probably monitoring was less of a priority. I mean, it makes sense, when you have staffing issues, when you have patients in the hallways, when you have no PPE, you're going to be focused on other things. And because of that, and the stressors under COVID, there's the heightened risk with respect to drug diversion. So we would recommend that you get drug diversion back on your radar. Make sure you have a multidisciplinary drug diversion response and prevention team in place. Next slide, Amanda, please. And make sure that you're monitoring this, and don't ignore the red flag of drug waste. Drug waste is always a strong indicator that you may have a potential diversion issue. Sometimes the nurse gets called away to another emergency and puts the unused 2 milligrams in her pocket, but other times it could be diversion. So make sure that this is on your radar and you're continuing to monitor it within your organization. Amanda, I'll let you do the next couple.
So HIPAA, I think I mentioned earlier, we've seen 19 settlements in the HIPAA right of access initiative. And everything that I have seen is they're going to keep on rolling. And so making sure your employees understand the HIPAA right to access, the timely provision of records to individuals that request them, and are really compliant with those right to access requirements that are outlined in HIPAA, and timely turning them over, because some of those settlements are quite hefty, the more flagrant of the violation, and so they've taken that initiative, and that those enforcement, every time we see a new one come across the board, I'm sometimes can't believe it, but at the same time, it's there. The information blocking rule, I think we've mentioned a couple of times today, compliance with that. We're going to be, Brooke and I are also going to cover compliance with the information blocking rule tomorrow at 9 a.m. So join us again there. Breaches and ransomware attacks, cybersecurity. This is a very unnerving, concerning issue. It's certainly escalating. We've gone from, they would just encrypt and not let you get access to it until you paid the ransom to get the decrypting code. Now they're actually exfiltrating your information. It's just becoming more of a large concern. So making sure you have the appropriate security risk assessments, following your incident response plan, documenting the following of that incident response plan as you have those ransomware attacks, because it is just happening more and more right now for our industry. Making sure you have your appropriate relationships with your business associates. This is something people kind of always get dinged on. There's been some audits in the past couple of years by HHS on your relationships with your business associates. So making sure you've got your business associate agreement in place. that they've also got the appropriate security measures and appropriately report breaches. Finally, social media, as far as HIPAA is concerned, is always an issue. You always want to respond to those posts by individuals, and you need, especially negative posts by individuals, making sure you're responding appropriately, potentially taking recourse against the website, not just going out there and saying, they were an obnoxious patient or whatever it needs to be, or whatever you feel is appropriate, making sure that you're doing a HIPAA analysis before you respond to social media posts, because we've seen a lot of people get in trouble for inappropriately responding to those negative posts or patient reviews. I've mentioned a couple of times today gender discrimination. This is kind of coming back to the forefront, especially with the May 10th, 2020 HHS notice that discrimination on the basis of sex is broad enough to include both based on the basis of sexual orientation and on the basis of gender identity. So we are back to that again. The Trump era kind of tried to back off of that, and this HHS notice moved us back into sexual orientation and gender identity being part of discrimination on the basis of sex. One good example of that, or one that we usually use in training on Section 1557, and particularly gender discrimination, is the Brooklyn Hospital settlement. Now, there was no penalties involved in this settlement, but there was a 2-year corrective action plan. What they had done was put a transgender female patient with a male roommate. And so part of that corrective action plan was revising their intake process and making sure their room placement policies reflected someone's identity, or how they self-identify themselves than their biological sex, if you will, or their born as sex. So with that gender discrimination being at the forefront and kind of a hot button issue probably within our society today, you want to revisit your sections 1557 policies, your non-discrimination policy, make sure it includes sexual orientation and gender identity. Update those administration and registration records, make sure there's multiple options for people to select, maybe not just male, female, or other, or prefer not to disclose, make sure there's plenty there so your staff know how to address someone or to provide the most appropriate care to that individual. Train your staff on how to interact with patients, maintaining professionalism, courtesy, and respect for those patients, that they know how to address an individual, that they know what pronouns the individual wants to use. And part of that, it goes into updating your patient bill of rights, making sure that they understand they have the right to be referred to as the pronoun of their choosing. And then with like the Brooklyn Hospital incident, make sure you've got your room assessment and maybe even your restroom access policies updated accordingly. And it's not just updating these two, it's making sure that your actual operations reflect what these policies update to, and that gets into your training. Oh, COVID-19. This is going to follow us for a very, very long time, I have a feeling. And part of that is Congress has invested over $5 trillion in COVID-19 related relief since 2020. That exceeded all federal spending in 2019. And so we're going to see, I think, a lot of enforcement actions related to the improper use of COVID-19 funds. In May, they announced the COVID-19 Fraud Enforcement Task Force, where they're reviewing, they've already got 60 reviews underway, auditing the various different COVID relief fund programs and the use of that money. So make sure you can track, if you received funds, make sure you can track the money. As there's been already 2,400 complaints of fraud, I'm sure there will be more. We've already seen the first prosecution of a Colorado physician charged with theft of 3 COVID-19 relief funds. All 3 of them, the Provider Relief Fund, the Accelerated and Advanced Payments, and the Paycheck Protection Program. I'm certain that this Colorado physician that was charged will not be the first and will not be the last that we see of enforcement actions related to the use of COVID-19 relief funds. Other places you can look to see where there might be enforcement trends in your area is the OIG work plan, which there's a link to that plan later in the slide. Your national coverage determination or local coverage determinations, which outline the various documentation that is required for a particular service, or the medical necessity behind a particular service. Those are always good places to look if you're constantly working in a particular area or industry or providing a particular service. So the overarching message, I think, is make your compliance program a priority now. I mean, it should always be a priority. Now is as good a time as any to make it a priority, and creating some sort of environment that is conducive to internal reporting and responding, and that open environment of communication, and that there's you don't, like I said, 90% of people reported internally. You're acting on that. You're responding to that. Don't forget to include everybody in your compliance training, both non-employees, privileged positions, your governing board, and particularly in worlds where your governing board may be people in the community. They aren't going to know about healthcare compliance, but they need to understand it as a member of your board. Utilize various teaching mechanisms. I think we've mentioned a couple of different times. Interactive training, make a game out of it if you think your employees would like that, and really use real world examples. Audit annually. Brooke spent a lot of time talking about auditing. Do on-site visits, do questionnaires, ask your people if they remember because too, if you do a questionnaire of your employees and they don't remember some of the basics of HIPAA, time to train on HIPAA. It's easy to pick your compliance topic for the week or the month. Another really big thing, and I don't know that we've spent as much time talking about this, is when people leave, conduct exit interviews. You can learn a lot of information when somebody is leaving the organization, that can help your compliance program.
This is the last tips. These come directly from the Office of Inspector General. And Amanda and I we respond to clients all the time with the first one. It's so true. Just because a competitor is doing something doesn't mean that you can or should. Clients, I hear that all the time. The hospital down the street, the physician clinic across town is doing this. And my response is, well, I mean, just because they're doing it doesn't mean that they're being compliant and in compliance with the law and regulations. So keep that in mind. Conduct your audits, know your risk areas, educate, train your workforce, designate, and most importantly, empower your compliance officer and your compliance team so that they can actually take action. It's more than a figurehead. They need to be able to deploy mechanisms within your organization to adhere to compliance and to correct non-compliance. Make sure that your management, your board, they're communicating a message of compliance from the top down. If you can't get buy-in from your board, from your administrative team, how is the rest of your workforce going to buy into compliance being important? Ensure you've got that open line of communication. If in doubt, ask for help. And that could be, another compliance officer at another hospital or physician group. That could be Missouri Rural Health Association. That could be reaching out to your legal counsel. But make sure if you need help, if you're in doubt, you ask for some help. And so I think we're a little bit over time, but with our break, I think we're right on time. These next slides contain the resources, links to lots and lots of compliance resources, the work plan, and it should hopefully be helpful to you all, the DOJ guidance document we referenced, and some other compliance program materials. We've also, I think, next slide, Amanda, our firm puts on a Health Law Institute in October. And so if you want to hear more about compliance and hot topics with respect to healthcare, please join us. We've got a link there. We're putting together the agenda now, and that'll be sometime in October. And then our contact information, if you have questions or additional follow-up, I know we didn't have time to get to questions, feel free to reach out. It has been our privilege, and we've been very happy to present to this group. I hope you found it beneficial, interesting. Just thank you for your time today.